Welcome to this panel on proactive use of data for the purpose of criminal investigations. You may have seen in the program that there was a slight mistake. We originally wanted to dedicate this panel to proactive use of data for terrorist investigations, and then we realized, well, it does not need to be. Of course, the focus will be on terrorism, but it does not need to be terrorists to be a serious problem with data protection. So we decided to widen it a little bit and dedicate the panel to the proactive processing of data for criminal investigations in general. Why did we choose this topic? We chose it because it's not new. Proactive processing of data has been going on for many decades. But what we think is new is the scale at which it's happening at this moment, and also the actors involved. We do see a lot more involvement of private companies, and we think that triggers a whole range of new questions that we want to deal with our distinguished panel that we have today. I will briefly introduce the speakers here. Just in between, my name is Elze Busser, I'm from the Max Planck Institute, and we organized this panel with the following members. I will just start on my far left. Philippe de Koster is Deputy Director of the Belgian Financial Intelligence Processing Unit, so he will give us a view on his expertise and his ideas and his thoughts on the processing of financial data. Next to him, we have David Murakami Wood from Queen's University in Ontario, Canada, who has a chair in surveillance studies there, and he will give us some very relevant and very new topics and new thoughts on new topics, I just understood, with some headlines from the news. Next to him is my colleague Tatiana Tropina from the Max Planck Institute, who is our expert in cybercrime issues and related data protection questions. And next to her is Dr. Ulrich Würmeling from Latham, Watkins, and also right now visiting professor at Queen Mary's University of London, who has a wide expertise and who will also focus on the processing of data coming from private companies. The moderation of the panel topics I'm chairing, and the person next to me is Niels de Oever, who is head of digital with the well-known group Article 19, who is actually an expert in freedom of expression, I understood. And
that just means I talk a lot.
maybe it does. But I leave the moderation in his capable hands because I assume that he will also give all our panel members then the freedom to express themselves within the relevant time constraints. So that was all from me, and I give the floor to Niels now to introduce the panel further. Thank you.
Thank you very much, Els. And I would like to welcome you all to the panel version of Minority Report. We are living in quite interesting times. The world is being taunted by terror. A privacy conference is sponsored by a surveillance company. The times, scale, and laws are changing. But how can we ensure that in a time where fear is very prevalent, fundamental rights are being protected? That is what we are talking about this morning with this very sophisticated panel that was just introduced to you by Els. Because of the relevance, importance, and timeliness of this topic, I would like you all to speak like words are hot potatoes and keep them really short and sharp, because I would really like to also hear the opinion of the audience and really like to get your questions. I would like to use the definition of question as a single sentence with a question mark at the end. So let's keep that in mind, and then we can have some real nice interaction, and I'll make sure to defend that definition as well. So I would like to start with you, Mr. de Koster, without further ado. So please go ahead, the floor is all yours.
Thank you, and good morning. Well, I will try to stick to the timetable, and I can summarize my ideas with just one sentence. When we are dealing with financial intelligence unit, whether in connection with criminal investigation or terrorism investigation or financing of terrorism investigation. And the sentence is just the following: not just joining the dots, but crossing the borders and bridging the gaps. What does that mean? In fact, within an FIU or a financial intelligence unit, we are collecting a lot of data coming out from either the Secret Service, the police service, the judicial service, the financial service, the banks, insurance companies, and so on and so on. And we are always looking at all this information, having in mind that we are supposed to send cases of money laundering, terrorism financing in relation with suspicious transaction. So we are collecting data, we are gathering it, we are analyzing it, we are supplementing this data, and then trying to build a case to submit to the judicial authorities. If I just go back to November 13th, what we've discovered just before, well, we've discovered nothing, unfortunately. And what was really puzzling, after the 13th of November, a few hours after this date, we've discovered that we do have all the necessary information to pinpoint the people, perhaps to stop the people, but nevertheless, we just have dots. We know that something could occur in different countries, but we didn't know the name of the people. That was not submitted to us, that was not submitted either to the French authorities or to other European authorities. So that's what I was just meaning by not just joining the dot, but crossing the borders and building the gaps. And we discovered that afterwards, we are always so perfect to find afterwards what happened and what we should have been in a position to do before. What does that mean? It means that we are supposed now to proactively use our data, analyze our data, but there's a step forward. Well, I can proactively look at my data, see whether I can find a link between names or financial transaction and so on, and the final purpose of these people. It's not always so easy because we are sometimes, well, blinded by what we are doing within Belgium and not thinking about what we should be done in other countries. What was also puzzling is that, well, on the 15th of November, I get a phone call from my colleague in Luxembourg telling me that he do have information which might be necessary for me and which might be useful for the French authorities. It's about one guy we are still looking at, or the police are still looking at in Belgium or all over Europe. And this guy was using a prepaid credit card. We do have prepaid credit card issued by the Belgian Post Office. And what the Luxembourg colleague do have as information was not the fact that the guy has used his prepaid credit card to spend some money. It was just information about attempt of using his prepaid credit cards all over Europe. When I'm talking about attempt, it means that for the Belgian Post Office, no financial transaction, that was no data. But for us, it was clearly a important data, just, well, following the routes of the guy, knowing that, for example, he was in Italy or he was in the south of Italy, and then we just check with the judicial authorities, discovering that the day before, the judicial authorities knows that he was in Greece, and they were wondering where he was going to move next. And I had the answer, knowing that he tried to attempt to use his prepaid credit card in the source in Italy. And that was it. And then we discovered that, well, the Belgian Post Office was not really aware or not really interested in this kind of, well, non-financial data, because it means nothing for them, no debit or credit of the bank account of the guy, but nevertheless, it was indeed useful. So what we did was to see how we can move forward in proactively processing our data. And within the group of FIUs, well, which is called the Egmont Group, we have now developed a procedure which is called the matching procedure. So it means that we are opening to a certain number of FIUs, certain number of trustful FIUs, our database, and they might come look within our, for example, the Belgian database on the basis of very specific requests with names, links to criminal investigation or links to a financial investigation, they can look within our database what we do have. What is the difference before and after the 13th of November? Before the 13th of November, we should have expect an official request from the Luxembourg authorities to go inside and to look inside our own database. After, well, we just, well, use the matching procedure. It's encrypted, so we don't know what the other is looking at or looking for. And when there is a match, I can open the file and tell the Luxembourg authorities, okay, there is a match there. There is something which might be of interest to you, but provide me with more information in order to enable me to open officially my file and to send you the information. It has brought some success up today. We are trying to enhance the procedure and to develop it. Mostly, well, it's on the go with France. It's also something we have undertaken with Netherlands. It's not big data and it's not data mining. We are still keeping our own data, but there, what has changed is that, well, we do know that we might have useful data in our own database, but we don't know who is interested in using this data. And the problem is, are we going to wait until we know where we are supposed to pass our data, or are we going to proactively work in order to enable each other to profit from the various data? Does that mean that we are, well, not respecting the data protection law? Certainly not. And we can only use these new techniques of data processing within a legal framework, knowing each other, knowing the limits of each other, and knowing that finally a misuse of any data collection or data spreading might lead to blowing up a judicial case. So we are not ready to do anything at any cost, but we still try now to look at this picture more effectively. And, well, we do have the dots. We know the borders, because for us there are still borders, but we are still trying to bridge the gap between us, knowing that we now think about what do I have which might be useful for somebody else. This is, well, my starting point.
Thank you very much, Mr. de Koster. I really you really understand borders well, because you really stayed within your time. Much appreciated. But I think you also gave us a lot of things to react on. And I would like to invite David Murakami Woods to do so.
Thank you. It's in some ways quite difficult to come after somebody who's got so much personal involvement with such a recent and deeply emotional and still, troubling situation. It's easy in some ways for me as an academic to make general comments on situations I don't have to take personal responsibility for when a terrorist attack occurs. However, I really appreciate the honesty with which you spoke, and also I think it's also very important to bear in mind that sometimes in these debates there's an assumption that data for preventing terrorism is some kind of magic technology. That somehow the solution is just if we had the data, if we collect it properly, and then we would somehow we'd find terrorists before they act. It's not as simple as that. It's no way near as simple as that. For many reasons, not just the kinds of issues around the difference in particular databases held by different people, the way in which data is collected, the incompatibility of systems, not just across national borders, but within national governments. Most national governments still can't even communicate between different ministries with different computer systems, let alone communicate across borders with different countries. The idea that somehow there's some kind of global database that we just plug into and magically find information out of, it's just not there. So that's for the first thing to say. Yesterday, as I was coming to this conference, this very interesting story came out of Canada, and I'm going to briefly talk more about the Canadian experience to draw on some of what to add to what we've been talking about here. The story was that Canada's Signals Intelligence Agency, CSEC, as it's for short, had announced that it was going to stop sharing some metadata with its international partners. This is very interesting news because officially it wasn't sharing any metadata with its international partners before. And one of the other big problems that this brings up in discussing these kinds of issues is that we don't know what we don't know. And in order to try to control, discuss, regulate the kinds of sharing of information, whether it's proactive or otherwise, it's very difficult to have a proper democratic debate about these things, because in most cases we're prevented from knowing even what it is that we are supposed to be discussing. And at times like after the Snowden revelations, for example, these informations come out and some national authorities will admit, yes, we are doing this or we are sharing this. Canada, in many of these cases, has really come off very lightly compared to, say, the USA and the UK. It's avoided, at least under the previous government, under the government of Stephen Harper, avoided taking much responsibility for what was going on. It avoided taking any measures to repair the damage that was done through the Snowden revelations, and took a stance which was basically nothing happening here, nothing to see. I don't think this was very helpful. In fact, shortly after the Snowden revelations, it was not necessarily directly related to it, the Canadian government introduced a new law relating to data sharing and data collection for national intelligence, the so-called Bill C-51, which some of you all know created a great controversy within Canada but also internationally, because it was one of the most far-reaching laws relating to the collection of data for these kinds of purposes. It's now under review, and some of you will be aware that the new Canadian minister of the new government of Trudeau has come to Europe and has actually been examining some of the systems used in Europe and in the UK in particular in the potential reform of this bill. However, it's worth bearing in mind what this bill in itself was proposing, as I think it's some of the main issues we want to discuss in this session. The bill was in some ways quite representative of a general trend in intelligence collection work, which was a move towards giving particular new powers, which in some ways were the recognition of what was already going on in much intelligence collection. What you've got to bear in mind when we talk about proactive investigation is that many agencies are essentially doing a lot of things already that are not technically illegal. And it's no shock for me to say that, even with somebody who's in this involved in the first place, is that there are many things that go on that, yeah, the NSA has not always adhered to the letter of the law in the USA. It's no surprise. We know that now through multiple phases. And this happens again and again. Whistleblowers come out and say, this wasn't being done properly. The NSA was collecting all this data. The NSA says, oh, sorry, we won't do it again. And then 10 years later, there's another whistleblower who said, oh, by the way, this new program was doing this, and it's exactly the same. So we had investigations into the National Security Agency in the 1960s and 70s, congressional committees that revealed wrongdoing. The NSA basically submitted to new forms of regulation, the Federal Intelligence Surveillance Court, and this had implications, of course, for all its partners across the world. Here we are again, 2013, and exactly the same kinds of accusations are being raised, as if none of this made any difference. For those who have faith in regulation, this should be a wake-up call. The idea here that regulation was a solution to wrongdoing just quite clearly was not the case. I mean, in some ways, there's a fundamental problem here which I want to raise for discussion, is that can you really regulate intelligence services? It's a great article of faith amongst especially Europeans that regulation is indeed a solution to many of the problems that we face, and that law will solve the problems we have with overreach and issues around privacy. What I'm going to suggest is that when you let certain kinds of intelligence agencies operate in certain ways, where their understanding of their purpose is that their job is essentially to protect the state, then you have a problem. And I don't know if that's true of every European country, but it's certainly true in the USA that the NSA and others see their job fundamentally as protecting the state. If that's the case, the will and willingness and interest of a particular government matters less. I think it's very important to bear in mind the difference between the government and the state here. The government is temporary. Governments change. The state, however, persists. This difference between, say, parliamentary regulation and inspection by a particular government, or a willingness to change something by a particular government, and the interest of the state more deeply, is actually, I think, a fundamental problem here. So while I appreciate the day-to-day difficulties of those involved in investigating serious terrorist acts, and I would never deny that those are a serious and pressing problem, I would also point out that there are very deep fundamental problems with a faith in regulation and law to deal with some of the issues that have come up through this, what we've seen through the Snowden regulations right now. And I don't know that we've actually addressed those, let alone solved those issues, or even approached any kind of understanding of how they might be solved. So I don't want to sound too pessimistic, but I think my lesson from this kind of headline is that if we don't even know what it is that intelligence agencies are now going to voluntarily comply with in the first place, it's very difficult for us to be satisfied that this is actually an adequate step. Is this agency trying to avoid regulation? Is it simply in advance of these reforms of Bill C-51, basically telling us there's no need actually for things to be reformed because look, we're already stopping the bad things we weren't doing to begin with. That's where I'll stop for now.
Thank you very much, David. And again, very much within time, and also some really hot and pointy issues there. Really nice. So, Ulrich, you have a high bar, but I'm sure you're gonna cross it and stay within time.
Well, the only bar I will cross is the time bar, but the
No.
let's see what's coming. So I was already introduced, Ulrich Würmeling. I've worked for 20 years as a lawyer and often advised companies as to their obligations or their rights to support authorities in all sorts of investigations. And the new thing, obviously, also in this conference, we will have to face is the European Data Protection Regulation, and I just want to explain how that's going to work in future if a company finds out that there might be criminal activities and wants to actually report that to the authorities, or if the a company finds out, for example, that there are tax issues in the company, or or cartel law issues, and they want to voluntarily report that and get the benefits of that voluntary report, and or if they are asked to do it. So basically, what we do, data protection law is very much about kinds of balancing of interests, and we have always used the so-called balance of interest clause to allow effectively this kind of cooperation between corporates and authorities, when to the extent it's voluntary. And the other thing that exists is obviously legal obligations. If you have to provide information, then you have to, and that's also justification. The regulation is to some extent a bit different to what we know so far. So it seems to indicate in one of the recitals that there's still kind of provision of data to authorities by companies about criminal offenses. But it actually has a very kind of bothering provision in there, which leads to, for me at least, to the conclusion that authorities under the regulation will have difficulties to get help from companies. And that is Article 9A. It basically says that you're only allowed to process data about criminal offenses when authorized by union law or member state law. So if you want to, for example, you have a video surveillance camera, you see on the video surveillance camera that somebody has been killed, then under this provision, unless you have actually a national law that allows you to keep that information, you have to delete it. That's exactly what it says. I'm entirely sure it's not meant like that. There are many things in the regulation that are probably not meant like that, but that's what this Article 9A says. So if you think about the question, how to deal with that, you then maybe want to go back to the kind of lawfulness provisions in the regulation and find something, but this Article 9A stands separate, and it's not kind of exempted by any of these lawfulness provisions, public interest, or legal obligations. So that just doesn't work, as many parts of the regulation don't work. It only works if national law actually authorizes. And that means within the next 2 years, national legislators have to make sure that they not only have in the law the kind of obligations, legal obligations to to provide data to authorities, but also allow that companies basically report on a voluntary basis, which most of the laws not explicitly state. So that is a bit of a challenge for national legislators, and probably the provision was more meant to target kind of registers of convictions and things like that. But it doesn't just refer to that. It refers to criminal convictions and offences. So any processing of data around that. So a big issue for national legislators going forward to make sure that the cooperation they enjoy today with companies will be possible to continue. Then the other big question obviously is, can you transfer data to other countries? Like we are in Germany, there's a French authority and has a request, or there's a US authority and has a request. The European Commission initially in an unofficial draft had a provision around that then went out before the official draft came out. Then the European Parliament came up with a provision, and now in the final draft there is something, Article 43A, and it speaks about the transfer or disclosure not authorized by union law. This relates to third country transfers, and so that is in a case when a US authority makes a request, and it basically says that these requests are not enforceable in Europe. That's actually not big news. These requests are not enforceable in Europe. A US authority can't enforce them in Europe. So that provision is actually totally worthless. It just states what we have in the law today. It doesn't answer the question whether you are allowed to transfer these data. And then we venture exactly into the discussions we had before, whether, for example, the request from a US authority might be justified by public interest in Europe. And international cooperation on, for example, on criminal investigations in terrorist attacks, I would personally say is a public interest also in Europe, because it is we are looking at situations of cross-border crime, and public interest it might be public interest in the US as well, but it's also a public interest in Europe that these investigations can be carried out. So the regulation doesn't really tackle that issue we have before, or we already have. It basically leaves it with the old discussions we had around it. So interesting, the only question is whether you actually have any of this information, because if you take it seriously, what I said before, you already have to delete it before you can transfer it. But that's basically where we stand. Not much clarification going forward. Just a big headache for national legislators to make sure that companies will be allowed in future to cooperate with security authorities to make and inform them about things they have learned, even in cases when they don't have an obligation. Thank you.
Wow, thank you so much. People are really doing it in this panel. So now we have Tatiana and I. Since we have had people performing so well, I'm going to put the challenge a bit higher this time for Tatiana. How are you going to connect all these different visions and critique them at the same time? You got 10 minutes.
Well, thank you very much, Niels. Actually, the bar is very high, so I don't know how I'm going to face this challenge. But I'm going to pick up on a few points from the previous speakers, previous panelists, and I'm going to connect two dots. One of the point which David made about faith in regulation, and one of the point which Ulrich made about private companies being allowed to transfer the data. And my point is rather not whether they will be allowed, but whether they will be enforced to do so. So I want to put the question of regulation from a bit different perspective to the debate which we are now having in Europe concerning the regulation of the duty to cooperate, either in criminal investigation or with intelligence agencies. Because if we are thinking about these complex layers of current environment of internet and telecommunications, we will see that most of the traditional companies like telecom companies, mobile operators, they are in this sense heavily regulated entities. The duty of them to provide the data, provide them in readable manner, in decrypted manner, is actually outlined either in the telecommunication laws or in the intelligence laws. And if we are thinking about all the unregulated, in this sense, entities, I would really like to point out that I'm talking about only this type of regulation. Like, for example, information society services, application providers. They are subject of the general duty to cooperate, which is quite vague. There are no frameworks. And we, I believe in Europe right now, what I hear, are stuck in this debate. Shall, for example, WhatsApp or Viber or Telegram, these kind of applications which are providing services on the basis of someone having a mobile number, for example, are they a subject of telecom regulation? And I believe that we are stuck in this debate because we are thinking either telecom regulation or no regulation at all, or maybe extension of the duty to cooperate. But if we are talking about the complex regime of data collection, and now I'm moving a bit from the regulation to the sensitive point about blurring lines between different kind of investigations and investigatory domains. So if we are thinking about criminal investigations, we have almost always strict safeguards, human rights protection, the necessity for court approval in many countries, except maybe United Kingdom, for example, in Europe. We have strict safeguards, but we have also other regimes, like, for example, preventive police investigations or signal intelligence, which where the regulation is much less obvious and the safeguards are much lower. So the sensitive point here is that this data will probably inevitably end in the criminal investigations. And the security architectures in different countries, for example, I was involved in several practical projects with law enforcement authorities, and one of the questions was, how do they share information? And the differences were immense, they were incredible, because in some countries they need strict legal frameworks, and in some countries there is just purely Chinese wall. We cannot share, for example, preventive police and criminal investigations. In some countries, this information sharing is a subject of strict frameworks. Like, for example, I think in Belgium there is a need for special committee, for special requests for this kind of information exchange. In some countries, like in Sweden, except signal intelligence, or in the UK, this information flows quite freely. And then if we are thinking about cross-border exchange, how these safeguards will be observed and who is doing the oversight. So coming back to the regulation again, the question of data transfers from private entities is in Europe calling for regulation, for telecom regulation for the purpose of criminal investigation, and or for the extension of duty to cooperate, which is very vaguely formulated. And I believe that to get outside of this box, of this strange binary choice, either no regulation or making them the subject of heavy telecom regulation, we have to rather think about, I wouldn't even use the word regulation, smart regulation, or kind of established frameworks, which will not be anyhow in the direction of telecom, but which will define how and what and with which safeguards data can be collected and transferred. So rather than the question of allowing private entities to transfer these data, I would say the question is, will they be forced to transfer these data, and how they will be forced? And of course, with the transborder component. And another related question, do I have another 2 minutes? Yeah, just briefly, because I think that we will discuss this. And another side of this debate is this question about encryption and decryption, about backdoors to encryption, or duty to provide decrypted information as a side of a duty to cooperate, or just about the law which is targeting everything and providing incredible vulnerabilities for encryption and security and privacy concept as a whole concept. So this might go just, I believe that this is also a very sensitive point, and also a part of the big question of faith in regulation and in faith of enforcement. And maybe we can debate this later. I would really like to hear the view of the panelists or of the audience. This is all from me. Thanks a lot.
Thank you very much, Tatiana. Well, this was pretty great from our panelists. And I'm not letting the audience off the hook right now. So we've heard so many interesting things that I think I should get at least 5 questions from you right now. So who is going to start off?
You've scared them now.
Yeah.
Really?
You have to explain the penalty.
Very good. The icebreaker. This is a privacy conference, so you don't need to state your name, but if you want to, you're welcome to do so.
Good morning. I am Juliana Vargas from Tilburg University. Well, I think that concerning terrorism, there should be international cooperation. And, well, what happens when a country is involved in a peace process with a terrorism group? Should countries, or will countries be willing to share metadata concerning ongoing acts of this guerrilla group that is involved in a peace process? I am asking this because I am from Colombia, and nowadays we are in this peace process with this group. Some people consider them terrorists, some other do not. So we are in this dilemma nowadays with this peace process.
Wow, the audience is even going over the panel. This is really nice, really nice. But I would like to take a few more questions if there are. Yes.
I'm Merel Koning from the Privacy and Identity Lab. I have a question for Ulrich. I'm wondering what the point was exactly about the remark you made about Article, I think it was 43A, because that's in line with the Cybercrime Convention and in line with...
No, it's just redundant. It doesn't do anything.
Okay, so...
It's that you could delete it and it wouldn't make a difference. It just says that foreign authority measures are not enforceable in Europe. That's right. It's not a wrong statement. Yeah, but if anybody thinks that we have put further restrictions into the regulation with regard to that because this article exists, yeah, that's wrong. That article does nothing.
Well, yeah. It does restrict ongoing negotiations in the Council of Europe with regard to extending the scope of Article 32 of the Cybercrime Convention. That is on direct access by police with data that's held by private entities. So to that extent, it blocks ongoing initiatives in the Council of Europe. So it's. I would see that it's.
I wouldn't see that
ensuring privacy.
No.
Okay.
Second question resolved. Who will pick up the first question? Would you be so kind, Philippe?
Well, I will try to pick the first question.
And while you're doing that, because you're doing that, you're getting the bonus to first react to the other panelists.
Okay, thanks a lot. Well, that's quite a very sensitive political question, and while my answer will be practical on the basis of 2 examples I did know. in my capacity of directing an FIU. A few years ago, there was the revolution, or the so-called Spring Revolution in the Middle East, and for example in Tunisia or in Libya. And the heads of these countries, Ben Ali, for example, in Tunisia, was known for years as being a corrupt guy. So we did have all the evidence in our country that the guy was being corrupted and sending money coming out from the corruption either to Europe, to invest either in Belgium or in France or somewhere else. We did pass the information to open judicial cases, and nothing happened until Ben Ali was still head of state. And then afterwards, well, everything started. So it's mostly a political game. So I'm just getting the data. I can use the data. I can connect it to a crime or a criminal investigation. But, well, okay, nothing is going to happen. It might be the same in Colombia while you're entering a peace process with people which were known as criminal terrorists and so on and so on. Does this is going to change the view on the acts which has been committed? Is it going to have any influence on the data you have collected? No. While data are neutral, you are just trying to use the data to establish that the guy was connected to either money laundering, terrorist financing, terrorism, or drug trafficking, and so on and so on. The same with Gaddafi. Gaddafi was in Brussels, welcome as a head of state, until, well, he died. And then, well, finally we discovered that this guy was quite a really bad guy. And then we were supposed to freeze all his money and so on and so on. But why have we done this after his death and not before? Well, that's a political issue, and I don't have any grip. I know that, for example, I'm not going to deal with political data. Well, I'm just taking the data, I'm just taking the intelligence, and then trying to build a case. And it's up to somebody else to deal with the case. Not exactly for me. But, well, the fact that, well, the bad guys are coming, well, acceptable guys or good guys, well, it doesn't mean nothing special for me at this stage.
That was a really great and really honest answer from, I think. And I'm very glad that people like you are in place who do try to avoid the involvement in politics. I think one of the really big issues here, when you have peace processes and armed groups, is the nature of the process. And the big question of what happens to data collected through intelligence in a peace process is the one that I think not many people have addressed. I think if you look at processes like the South African peace and reconciliation process, a lot of that was presaged on essentially a form of truth-telling, and then after that, a kind of organized agreement to forget and move on. Not to forget, but to move on beyond that truth-telling process. You have truth-telling followed by moving on. The problem is, in a big data world where nothing is really forgotten, moving on, truly moving on, becomes very difficult. And so I think one of the issues with peace processes in this world we're entering now, where nothing is ever forgotten, essentially whatever the European Union says about Google, nothing is ever truly forgotten, is that those processes become far more difficult to operationalize in the way that they used to be. So truth and reconciliation becomes something different in a big data world than it was in a world where paper records, where you could actually agree to remove, destroy records and move on as a society. So I think that's an open question. I don't have necessarily a view on that, but I think it is an enormous question, and I'm very pleased that it was raised.
Was that question sufficiently answered, or you have a follow-up question? Because clearly the case has sparked quite some interest.
It's okay. I know it is a big issue and it's complicated to have a exact answer, so it is good. It's key. Don't have any following questions arising it.
Thank you very much. I would like to... there is another question there in the back.
Hi, my name is Paula Bielski from Leuphana University, and I just wanted to take up what Tatiana was talking about at the end in terms of anonymous communication and backdoor decryption. I'm just wondering if any of the panelists can give me a little bit more information. I'm studying anonymity issues, and I'm curious what's happening in this space and what are the, because we know it's a sensitive topic, we know a lot of criminal activities happening under kind of closed anonymous doors, and I'm just wondering what is happening right now in terms of kind of the legal regulations, or as you call it, backdoor decryption. What does that mean? Yeah.
Thank you very much. So the debate is now, I know that there have been calls, for example, in the UK and in some other countries. Some countries have already made this decision, like France announced recently that there would be no backdoor to encryption. There is a call to make all the companies who are providing encryption to provide the backdoor for the government for the purpose of criminal and terrorism investigation. Why I do find this unacceptable, like more like the major part of the technical community and privacy advocates, I believe that this, first of all, creates an immense vulnerability. It's not only people who are using encryption. Just from my experience, when I first installed Telegram Messenger, I found out that half of my contacts are law enforcement agency people who are using Telegram, and at the same time asking for backdoors to encryption or for ban on encryption, which I find a bit strange. This is the first point. Secondly, I like how it was called by paper written by Schneider and some other guys. Providing backdoor to encryption is like leaving the keys under the doormat. If the backdoor is provided, the vulnerability is created. So it's not only law enforcement who can access this data. This vulnerability can be compromised by criminals as well. And we should not underestimate them. They are already using many backdoors which were created by law enforcement agencies for different purposes. So I believe that this debate, but the question is how to solve this. So I know that if we are going to walk in the shoes of law enforcement agencies, it's really hard because many of the information they can get would be collected only from the metadata, because then they cannot get the content of communication. What are the legal solutions for this? Either in criminal investigation, and I believe that better to use it for criminal investigation is remote forensic software. I think there has been calls for this in the UK, for example. France, Spain, and some other countries in Europe have already adopted this measure. I do think that this is very controversial. So, but at least it doesn't create vulnerability for the whole encryption. So you just install something on the computer or on the phone of the suspect and you're collecting information in real time. This is a very intrusive measure. So I'm still torn apart on to which degree I support this measure. And also because it consists of several things. First of all, you have to hack remotely, and then you have to install, and then you have to get data remotely. So getting data remotely is already covered in many countries by traditional provision on surveillance, for example. But remote hacking is not. And so if this is considered, I think that proper safeguards should be implemented in this sense. So I think there are some also very intrusive but still alternatives to backdoors and or to ban on encryption. And though I still have controversial opinion about I'm not really yet decided on what I think about remote forensic software, but I believe that if we choose it as an alternative to backdoor to encryption, there should be really proper safeguards implemented for both criminal investigations and intelligence purposes. But ban on encryption or backdoors to encryption is clearly no-go.
Well, it's really quite interesting because, well, I was just thinking with this backdoor encryption, and well, may I be interested in using all these instruments, or even work with law enforcement agency involved in this? And it's, well, I'm just coming back to one of the basic question: do we need more data? Well, just use the data you can collect today and try to see whether it's useful or not. what about backdoor encryption? Okay, it's opening the door, and then you are not going to start to find the starting point of your exercise. Okay, if you need to go inside a system just to get ensured that you do have the right information when we are talking about criminal investigation, I might understand the need for it. I'm also, well, a prosecutor, so, well, I'm also dealing with cases, and of course, sometimes we are, well, stopped in a case because we don't have the means or the technical means to get the final evidence which could be presented in front of the court. But, well, the question, and I can share part of the views expressed by Tatiana, providing a new instrument and just saying, okay, well, backdoor encryption, law enforcement agencies can enter whatever, whenever they want and whatever computer they want in order, well, for security reasons. That's not appropriate. Well, I cannot accept the idea of being able to do everything or to get the power to do everything, use all the means, and then what? Well, I have a day-to-day business, and I have to achieve something on the day-to-day business and see, well, under very specific circumstances, whether I need more sophisticated instruments or not. When we are talking about backdoor, for example, my FIUs is cooperating and working closely with the Secret Service in Belgium. And normally, well, the Secret Service in Belgium are compelled to provide us information. So I do know that the Secret Service in Belgium might use the very special investigative techniques or intelligence technique. I know that they can use it. It's up for them to use them under the law, the Belgian law, and I don't care about being able to use the same procedure as them. It's their job, not mine. What I would like to have is proper data collected by them, presented to me, supporting my financial intelligence, and together we can come to the prosecutors with a well-built case. Don't forget that the more you are using the instrument in a wrong way, and, well, I perfectly understand the debate which might occur with the backdoor encryption. Well, as a prosecutor, I would like to have the people condemned by the court or not condemned, but I don't want to waste my time opening a debate in front of the court. Okay, you do have guys in front of you, and you are supposed to condemn these guys. But first of all, let's talk about backdoor encryption. Let's talk about the means which were used and so on. And we can spend days and months and years discussing about, well, technical issues which might be solved previously. That's it.
And that brings up a very interesting point. I think that's, once again, a very insightful and honest answer. I don't think you get that kind of honesty from some officials in similar positions in, say, Britain or the USA, actually, having been on panels with them before. One of the interesting things is that when you talk about backdoors to encrypted devices or software, that actually there is no single unified position amongst law enforcement and intelligence organizations. Sometimes the media would lead us to believe that all these organizations want backdoors, and they want them now. But let's look at the debate that's happening in the USA right now. The FBI has strongly demanded backdoors to encrypted services, and in fact even banning encryption in some circumstances. The head of the NSA came out the other day and said, no, not only do we not want it, but it's actually impossible. Like, most of what the FBI is asking for is impossible. Now, there's two explanations to this argument. One is that the NSA has, of course, the technical expertise and understands this better than the FBI, and is making its argument from the point of view of people who understand encryption. They are the people, after all, who make encryption, and most of the standards in the world have some influence from the NSA. The cynical argument is that, in fact, they simply don't want the FBI to have the same facilities that they have, and that they indeed can work quite well with currently encrypted software and maybe can break things that we don't know they can break. And so what they're trying to do is protect their domain. That's the cynical explanation for this argument. I'll leave it to you as to which of these explanations is actually correct.
There are questions. Questions always welcome.
Yes, hi. I'm Mark Lang from Microsoft, and I want to return to the question about the proper basis for transfers of data out of the U.S. for criminal justice investigations? Because we're obviously in the middle of dispute about that. And Ulrich, you mentioned Article 43A and that it doesn't change anything. And I wonder if some legislators thought they were trying to change things, or at least clarify that the proper basis for transfer of data was through mutual legal assistance treaties. But you're saying that it doesn't change anything, and the status quo, actually, from what we see, is total confusion. Many people think MLAT's required, and many people think they're not. And so I wonder if you could elaborate a little further on, if you're saying 43A doesn't change anything, what is your view of the status quo, and is the public interest exception enough as a basis for transfer of data for all criminal law enforcement investigations?
Thank you. Obviously, you are in an interesting case in New York about that type of question, and I've under the existing rules, I do believe that the only way to justify is public interest, and putting it into a broader context in the sense that cooperation in kind of criminal investigations on an international level is in the public interest of every country, not just the one where the investigation happens. Yeah? That might limit the type of requests you can answer, yeah? Because there will be investigations that only relate to something that happens in one country, and maybe it doesn't have that kind of international terrorism aspect to it, or kind of international organized crime aspect to it. So but that point, I think, still is going to be tricky and leaves us in a mess. So there's, in my view, it's always preferable to clarify through international agreements what you can do and what you can't do. The for 43A, you ask about the intentions. Jan Albrecht fought very hard for this provision in order to limit data exchange to the US, and he lost. He didn't reach anything. The only thing he reached is a few words that mean nothing. If he wanted something else, I know that, but he couldn't persuade the other parties involved to do it. And so it basically says any judgment or administrative order may only be recognized or enforceable in any manner if based on an international agreement. Yeah? That opens the world for the Cybercrime Convention or things like that. But that is the case. We have nobody has ever disputed that. A U.S. authority can't enforce a request in Germany or France or Belgium. Yeah. You can fly over and try, yeah, but they might actually not get the 4-star Hilton hotel they were looking for. Instead, they land into prison somewhere unless they were going under immunity. So that's just not new, yeah. And then this provision explicitly says at the end, without prejudice to other grounds for transfer pursuant to this chapter. It explicitly says that everything we had before, and mainly the third country data transfer provisions are what we had before, everything is still applicable. So you can certainly go back to public interest, but you will end up in the mess we are in today. So no clarification, it doesn't get stricter, it's for companies just the same mess as it has been for the past years.
I'd just like to add something. One of the interesting things about when you have controls, regulations on data movement and so on, is that if they become too onerous in one or other direction, then there's always workarounds. And as a social scientist, I'm very interested in how organizations work around regulation rather than just actually try and implement regulation. One example, of course, is between Canada and the USA. Canada has much stricter privacy laws than the USA in many regards, although some of my US colleagues will disagree on that. And in theory, Canadian, say, personal information when people take flights is protected in a much stronger way than that in the USA. So what happens is when Canadian flights, for example, airlines taking off from Toronto, not going to fly over US territory, and fly to Europe. You would think this is not covered by, or should not be covered by any US regulation. However, of course, in order to get past the problem of how US is going to obtain data from Canadian companies and go through all that process of trying to obtain data for all the standard ways, instead what the US did was just declare that it was actually that everybody flying within a certain distance of Canada would now have to provide their data to the USA. And essentially all the major Canadian airports, Vancouver, Toronto, Montreal, all within that area. So essentially, by fiat, the US can declare that this will happen. Now, of course, in practice, Canada could say, well, we don't agree, and we're not going to do that. But that would basically close down every Canadian airline and aviation industry, and would cause an international problem because, of course, Canada is a very small country compared to the USA with very limited powers. And a lot of the way that international data transfer has worked recently, especially since 9/11, has proceeded by this kind of, I wouldn't call it government by threat, but it's more like a kind of pressure, subtle or otherwise, is exerted by large actors over smaller actors. You can see this with anti-money laundering legislation as well, which came about largely through voluntary compliance with US standards. But the voluntary compliance means if you don't comply, then you would not be able to trade with the US. So essentially that means you have to comply. And that kind of soft power, as some people call it, though it's actually far from soft in practice, is very, very important, I think, in these. As important as whatever any particular article says or any particular treaty might propose. That's my view.
Yeah, I would like to pick up on this a bit and again put it into the regulation perspective, because there are some debates on if we are operating in this lawless space with some soft powers and back channels for cooperation. Wouldn't it be better just to legitimize it? Just if we already have it in place, why don't we put some regulation and just say, okay, there is a framework? And just my personal opinion, I think that it's like legitimizing Wild West. So we are operating in a Wild West where power means a lot, and basically putting in place regulation which will legitimize it, it will be a legitimization of this Wild West and application of power.
The question is, which sheriff do you pay attention to? There's more than one sheriff in town still.
Exactly.
Any more questions from the audience? Really?
If not, maybe we can continue a bit on the debate of obliging companies to do something or giving them the right to do it, because I'm actually, what I see in my practical life as a lawyer is that the companies, if they get kind of informal requests and things like that, they want to know, what can I do? What can I answer? And you came with the argument, we need information to build cases, not kind of whole servers with 1,500,000 emails. Yeah? So the companies who can actually help on that, I think they would be happy to do so if they would be in a position where they know that doesn't get me into prison if I do it. Yeah, that doesn't get me in trouble with the data protection authorities. And the fact that that an investigation authority tells a company, please provide it, it's okay, doesn't mean that the company doesn't get fined by the data protection authority. There's not one government. Yeah, we had cases where we said, okay, investigation authority, please talk to your data protection authority, agree on what we can do, tell us, and we will. Yeah, they didn't even talk. They said, we are not talking to them. And that's, but from a company perspective, it's a relationship between the company and the government. Yeah, and it's really frustrating. Yeah, and and I think in terms of building success in investigations, making sure that there's a clear framework with the protections that it needs around it for companies to actually voluntarily provide data on the basis of informal requests, would be a huge step. Anything you do obligatory becomes something where you're basically losing that type of cooperation with the companies. So I wouldn't like to see kind of data retention type of laws for every company or things like that. Huh?
Well, it's interesting because it's opening a debate which had been opened by the European Commission, but not right now solved. You were just talking about the duty for companies to provide information. Well, I can talk about the companies being compelled to pass information. It's a totally different framework. You are talking about the data protection regulation. I can talk about the data protection on money laundering, the regulation on money laundering and terrorist financing, where companies are compelled to pass information. And then we had this debate within the European Commission with banks, for example, saying, okay, well, I'm compelled to provide information to FIUs. But on the other side, the protection agency in Belgium, or the data protection agency in Belgium, is going to fine me because I'm passing you too much information. And then the DPA is coming to me. What are you asking for? Well, I'm just asking for data. I'm not asking for everything. They might provide me with useful information, and I won't tell them what they are supposed to gather, but I will ask them to provide me with useful information. And there is a conflict between these two regulations right now, and it has not been solved. On the one side, I can compel banks to pass me information, but up to which extent? And on the other side, the data protection regulation is coming there, saying, okay, be careful. If you, cross the border, then you will be fined. And what is also funny and very cynical, and as I think it was coming from a UK companies, okay, I can solve the problem. The fines within the money laundering regulation are lower than within the DPA. So I will always follow the data protection regulation. It's cheaper.
Well, that when after kind of 3-hour consultation on a legal issue, we also come to these issues. Yeah, obviously what is more expensive in terms of fines, but it brings being stuck between obligation and restriction, both the obligation and the restriction being penalized. Yeah. Is, I think, the problem. If there would be something, an area in between where you don't have to, but you can, yeah, that basically safeguards you from these overlaps, because we are tightening up obligation and right so close that it actually overlaps in the other direction, where you get a gray area where you might be breaking both. I think that can be solved with having a good area where you can, but you don't have to. We actually have that in Germany in relation to the medical secrecy rules. If you think about the pilot that put down the airplane with the German wings, the question was, why didn't the doctors tell the airline that he isn't fit to fly? And there we have this kind of 3-cluster system. There's a situation where doctors are not allowed to tell. There's a situation where they can tell, and there's a situation where they have to. Yeah, and this is quite good balanced out. If the doctor would have known kind of more about what could happen, he would have been at least in the area where he could have told, even and maybe already in the area where he had to. And when we look at public authorities gaining access from companies, we are somehow just trying to get to basically limit this area where which is the buffer in the middle, and that's where the problems arise.
Just briefly, I mean, one comment I'd like to make on this is that this seems to be largely a discussion between corporate issues which companies want to have a kind of predictable framework, and on the other hand, certain kinds of state organizations which want to achieve a certain goal. The other question, of course, that none of us have mentioned here is that which of these frameworks provides the most accessible and remedy for accountability for the general public and individuals? So there's not only that question of, yeah, and that may be the way to go, is to think about, in the end, to resolve this problem, is to go with the system that provides the most clear set of remedies and accountability procedures for citizens. And then one might actually achieve at least some clarification as to what's going on. Because I think an argument between corporations and the state is, and governments is almost never going to be resolved like that. So that's as a non-lawyer.
But that's because of the governments.
That's a very European perspective.
As someone with a technical background, I like the simplest option is the most is often the best. So that sounds very good. I'd like to give an opportunity to the chair to summarize, to see what we've gathered from this and how we should thinking while walking out towards the next session, which also will be very interesting, I can tell you.
Thank you all. I think we heard, thanks to our panel members who remain very concrete, we heard many one-liners today, and one that I'm taking with me is, do we need more data? Thank you for that point, because it's something that we very often forget. To wrap this whole session up, I want to thank the audience for challenging our panel members with very provocative and very to-the-point questions. It's important that we have people doing that. But most of all, I want to thank each and every one of our panel members, not just for staying within the time limits, but most of all for being concrete. With this kind of topic that has many, many aspects on many levels, it is very easy to fall into general statements and general arguments, and you didn't. And I congratulate you and I thank you for that. So please join me in a round of applause for this panel. Thank you.